Hi, my name is Amber Thaling. I'm one of the attorneys here at the Elder and Disability Law Firm, and welcome to our Google Hangout today. The topic for today is powers of attorney. We're going to kind of go over some basics and 101 information, and we're going to start the slideshow and get started. So welcome. Thank you for tuning in. Okay. So, powers of attorney. People have a lot of confusion about what powers of attorney versus wills, or a last will and testament versus a living will. So hopefully the information that we're going to cover is going to clarify some of that. There are essentially three main types of powers of attorney. Working on the slide here. There we go. And so we're going to go through these in turn, but here's kind of the general overview. There's general or financial. So this covers the basic day-to-day affairs of somebody that's non-medical. There's durable, and so it survives or remains valid after incapacitation. So being competent or incapacitated doesn't affect the document, therefore it is durable. Non-durable means it becomes invalid or is revoked upon incapacitation. So it is only in place when the person actually has capacity. Kind of a weird way to do it, but the thought process behind that for some people is, well, I can still check up on them if I have capacity. So when I lose capacity, I no longer want them involved. The other one is a springing. There has to be a trigger event. Typically that is incapacitation, however it could be something else. There's a special or limited power of attorney, which is basically it's for a special event or occasion, and the limited is for a set amount of time. And then of course there's the healthcare and medical advanced care directive. Let's talk about kind of the POA vocabulary, the 101 if you will. First is the power of attorney itself. That is the name of the document. The principal is the person who is signing the document, who's saying, I want to appoint the next in line, the agent. So the principal is the person signing, creating the document. It's there for their benefit. The agent is the person they're appointing. Some people also refer to it as an attorney-in-fact or power of attorney. Third party, which means basically it's the person who can rely on the document. A bank, financial institution, car dealership, you know, the insurance company, KCP&L, whoever it might be that the agent is providing the document to. The third party can rely on that. Incapacitation, which is typically it requires two doctors to say somebody's no longer competent to manage their day-to-day affairs and to make their own financial decisions. And next we have the advanced directive or living will. That's actually separate from a healthcare power of attorney. And we'll cover the details of that here before too long. Okay, so first the general or financial power of attorney. Again, we talked about the three before. There's the durable, non-durable, and springing. And it covers everything non-medical. Bank accounts, the real estate, insurance, IRAs, 401ks, stocks, bonds. It can cover safety deposit boxes. But keep in mind, it's only going to cover what is listed in the document. So it has to specifically be laid out. And here in the state of Kansas, if you own real estate, your homestead, the legal description actually has to be listed in your document itself. So the next we come to the special or the limited power of attorney we refer to. Limited duration, I'm out of town. This can be the snowbirds, you know, people who go to Florida or Arizona, they appoint somebody to take care of their residence or home that they have here. You can take care of, you know, paying the bills, collecting my mail. You know, if the pipes burst, you can call A.B. May and have things taken care of. And then we have the limited scope, a specific transaction. I authorize you to go buy a car from me. Or I authorize you to deal with the IRS, such as maybe your accountant. Or, you know, somebody else who's managing your affairs, but you want to give this one person a very limited scope of a specific time or a specific transaction. Okay, next we have the healthcare directive and advanced directive. So the power of attorney portion of that document, sometimes they're two separate, and they are two separate documents. We keep them combined in the same document, but they're two separate pieces. So the power of attorney, the person you designate can make general healthcare decisions. They can hire and fire doctors, admit and discharge you from hospitals, review medical records, sign off on organ donation, autopsies, things like that. The living will is the piece that if you are in the final stages, if you are terminally ill, it's your option or opportunity to speak towards, if I become incapacitated and I'm terminally ill, these are my wishes. This is what I want to happen or not to happen if I get to that place. And the next question is, why does somebody need a power of attorney? I'm competent, I'm fine, I'm young, I'm healthy. So there's a few examples that we'll go through. What happens if you are in a car wreck? Who's going to pay the mortgage? Who's going to call about your apartment rent? Dealing with the insurance company on your vehicle, maybe it's your health insurance, something with your home comes up, paying the basic bills. So even though you are still competent, you can still have somebody step into your shoes, go to the bank, make deposits, make withdrawals, take care of things for you while you're physically not able. Also, there's the example of having a loved one in the military. They're overseas. Something happens, they can't get online and pay their bills, or they're actually unconscious. It allows you to then step into their shoes, and kind of like the car wreck situation. Call about insurance, make phone calls. Medical is really important too. They get hurt or wounded, who's going to be able to authorize treatment for them? And then basically similar with if somebody has a stroke or develops Alzheimer's, dementia, or any other physical limitation. And so next we'll talk about the basis of medical decision making. Each person has the right to make their own decisions about the health care and to be an informed consent. The advance directives allows the principal, the person making the document, to document their wishes with regards to healthcare decisions, recognizing that at some point they may not be able to make those wishes known. So if somebody does become incapacitated, whether they're in a coma or have significant memory loss or other issues, they're able to speak to what they would or wouldn't want in advance. And then the question is there an advance directive? The advance directive is the living will. If I become terminally ill, what would or wouldn't I want? If a client is not now competent, the question is, did they document their wishes when they were? If there's a living will, does it adequately address the current questions or issues that they're dealing with, that they're facing? And the power of attorney, the only limitation in the advance directive, restricts the scope of the agent's decision making. So they only have the authority of what the document gives them. So they have to be specifically listed. And then next we talk about, so what if there's a medical emergency? The question that the physicians will ask, have they expressed their wishes? Have they talked to family and friends about what they would or wouldn't want? And primarily, is there a conflict as to the opinion of the patient's wishes? So a doctor is sitting down to talk to the family about, okay, this is what should or shouldn't happen, or these are the recommendations. You can choose plan A or plan B. One side of the family says A, one side of the family says B. The power of attorney and or advance directive would then deal with, this is what I would or wouldn't want, and this is the person who I've appointed to make my decisions. The fun part. So where do I get a power of attorney? We get this question a lot. And so you do have options. There's the internet. You can use a form book. Office supply stores usually have software, or nowadays you can download it from the internet. Legal aid or an attorney. And what we always tell clients here is you get what you pay for. It doesn't happen with every client, but it happens frequently enough. A financial institution wants to push back. Well, we need this, or it doesn't have that. And our document covers everything from A to Z, and we've never had a problem with it actually being honored, but we've had to fight for our clients with it. Well, we need this form signed, or it requires incapacity. Well, actually, the way our document is structured, the client's document, is that it doesn't require that. So if you've used a software program, a form book, the internet, you don't have anybody to back that up for you. And if the person you're acting, the principal, the person you're acting on behalf of, no longer has capacity, you're stuck with what you've got. And so then the next option would be, if the power of attorney isn't working and they don't have capacity, then you have to go through guardianship, conservatorship proceedings to be able to manage the things that you need to manage that weren't listed in the power of attorney itself. So it really pays to hire an attorney to do those for you. And so next we will talk about the legal requirements. So what is required for somebody to be able to sign a power of attorney? And what does the document need to have in it? First of all, there's legal capacity, or what we call testamentary capacity. You have to know who you are, who you're appointing, what you have or what you own, and the effect of the document, the powers that you're bestowing on somebody to act for you. So I am giving you full authority to open and close accounts, buy and sell real estate. You have to understand, they have to understand, even though they may not know the name of the document, they know the power that it holds. They also have to know, they call it the objects of their bounty. I own a home, I have bank accounts, and the people that they're appointing, whether it's family or friends, I trust them. I trust them with my money, I trust them to make good decisions on my behalf and to act, responsibly. It has to be written. The person who, the principal has to sign it. It needs to be dated and notarized. Not all states require notarization, but Kansas and Missouri do. It also, some states require witnesses. Missouri does not and Kansas does. And so in order to have, if the document is challenged, the question is, will it survive the scrutiny? And it needs to have all of the above listed in order for it to be valid or upheld. So that's the financial. So now we'll talk about the healthcare power of attorney. It has the same requirements as the previous one. Keep in mind, though, a healthcare power of attorney, as long as you are able, you make your own decisions. So it is what we call naturally springing. It is the trigger event. Something has to happen, because as long as you're able, you may physically not be able to get out and about, or you may be in a body cast, but mentally, if you're capable of making your own healthcare decisions, you do. And it also will ebb and flow with your capacity when it comes to healthcare. You're in a car accident and you're in a coma for 6 months, your agents step in, they make decisions, you recover, you go back to making your own decisions again. So again, it will ebb and flow with capacity. The next people say, who should I name? They have to be of legal age, someone you trust. It may not always be your family, it may be friends. We usually suggest having multiple agents. And, whether you list somebody individually, I list Susie, and if Susie's unavailable, then Johnny, or you can do what's called joint and several, which means either Susie or Johnny can act. Some people are only comfortable if the agents, if they've appointed multiple agents, acting jointly. So they have to act together, they have to agree, they both have to sign off. It can be cumbersome, but sometimes that's what clients want. And you also want to make sure there's an alternate or backup. So if Susie and Johnny are sick or they die in a car accident, who then would step in? So it's always a good idea to make sure that you have a backup to your primary agent. We can go back to the someone that you trust. If there's nobody that you trust that much, then you shouldn't appoint them. Well, they're my kids. It's my son, it's my daughter, it's my sister. If they're not good with money or you don't trust them to take care of your money, then you shouldn't appoint them out of obligation. You should really look, in your community of family and friends to see who you would trust to take care of those things for you. Then we also have the liability of the agent. So they have a fiduciary duty. They have to act in your best interest. They may not always make the best decisions, but they have to be acting in your best interest. They may invest in some stock that doesn't do well, but they were, trying, basically. Next, the agent is not personally liable for the principal's debt unless the agent personally guarantees that those debts will be paid. So we always tell people when they're signing for the principal, you're signing, you know, mom via daughter POA. So always sign it on behalf of the principal, not the agent themselves. And the agent's creditors cannot attach the principal's assets. So if I've listed, you know, if mom is listed Susie, then mom is not, Susie's creditors cannot come after mom's money unless the agent and the principal have commingled their assets. So if we have joint accounts, joint investments, then yes, Susie's creditors can come after the money that's got mom's name on it as well. Also, the agent is not personally liable on contracts made on behalf of the principal unless, again, they personally guarantee the contract or they've acted outside of the scope of authority. So if they've done something that the power of attorney didn't allow, then they can be held liable for that. So the next, the liability of the principal. What are they responsible for? So if the agent acts within the scope of their authority with the powers that have been given in the power of attorney, the principal is bound to that agent's decisions. I trust you to handle my IRA, my 401k, my investment accounts. So if the agent buys, sells, reinvests, that power was in the document, and if the agent was truly acting in their best interest, the principal is bound to that. If the agent, though, has acted outside the scope of authority or has breached the fiduciary duty, the principal is not bound to those actions. So here are some things that can be listed, powers that the power of attorney will cover. Things that you can assign to people, and then there's things that you cannot assign to people. So it's general powers, the gifting, Medicaid planning, you know, buying and selling real estate, amending some estate planning, you know, changing beneficiary designations, you know, when it comes to the health care, nominating a guardian for them, patient advocate, you know, consenting to medical treatment. The powers that they can't do, they cannot do a last will and testament. Your healthcare power of attorney cannot make a living will for you. That's something that you have to do on your own. They can't make you do anything against your will. So an agent can't force you to do something. And then they can't carry out any action specifically forbidden by the principal. So if the power of attorney says you can't gift or you cannot sell my real estate, then the power of attorney cannot do that. Okay, so next we'll talk about the healthcare power of attorney. Again, kind of covered on the page before, but the powers that are allowed, they can sign off on autopsies, anatomical gifts, consent or prohibit medical treatment, which, you know, hire and fire doctors, admit and discharge you to hospitals, review medical records, all of that kind of fun stuff. Again, they can't create a living will. They can't make you act, and they cannot override your wishes. So if you've documented your wishes in writing, they can't override that. So at some point, if you decide you no longer want your agents to act on your behalf, you no longer trust them, they're no longer available, then you can revoke it. As long as you have capacity, you can revoke the power of attorney. If you've had the limited or special power of attorney, it has an expiration date. So it's limited in its duration or its scope. If it's to buy a vehicle, when the vehicle is purchased, the power of attorney is done. Death automatically revokes it. Your power of attorney actually ceases at death. It is only valid while you are alive. So while you're alive and you no longer trust Susie to take care of your affairs, you need to collect and destroy any of the copies and, of course, the original power of attorney. Make sure anybody that you know has one, collect it. You need to notify the agent that they're no longer able to act on your behalf. You're withdrawing them. And if you know of any of the financial institutions or people that have a copy of the power of attorney that are relying on that, that you notify them, hey, I've changed my power of attorney. You call your, you know, agent at Charles Schwab and say, Susie can no longer do anything. I am revoking that. So as long as you know who they've been dealing with, you need to notify them they're no longer able to do that. And of course, if it's the non-durable survives capacity, you must have the capacity to do so. So as long as you're competent, you can revoke the power of attorney at any time. Once you become incapacitated, the document stands as it is. Nobody can come in and change that. If somebody is violating their fiduciary duty, not acting in your behalf, then somebody could petition the court to have them removed if you're not able to do so yourself. So we've covered the who, the what, the when, the why, and the how. We recommend that the power of attorney be durable so that it remains effective after incapacitation. If you've trusted them with your finances, it's a good idea that obviously that it survived the incapacity situation. And because that's really when you're going to need it the most. And then the question is, you know, if you can't make decisions for yourself, do you trust the people that you've appointed? It's very important that you do, because they will be able to basically step in your shoes and do as you would do. So it's always a good idea. We recommend to clients, look at your documents every 3 to 5 years. Take a look at it. See if it's still the way you want it. If there's a big trigger event in the family, a death, a birth, a significant change in health care, some, you know, big event, go back and look at your documents and make sure, you know what, this is still the way that I want them, or you know what, maybe it's time to change or update them. So at this point, if there are any questions, I will take them. I'm sorry, actually you just need to call the office and call any one of the numbers. You will reach the receptionist, and she can direct your call to the most appropriate person to answer them. Hope you enjoyed the presentation, and we look forward to you tuning in the next time.